Robert Florio held the paper aloft in the courtroom and demonstratively jabbed his finger at the words, University of Louisville, printed in the top left corner of the complaint. Florio, the attorney representing a group of Louisville men's basketball fans in a lawsuit against the NCAA, looked pointedly at the two lawyers seated to his right. "We're not asking the University of Louisville to participate in the lawsuit, but they're acting like we are," Florio said. Quote, "The university can't stand in our way of getting to the NCAA because they breached their contract to us." More, NCAA announces widespread changes to college basketball. Recruiting U of L's inclusion in the lawsuit was at the heart of arguments made in court Wednesday in front of a Jefferson Circuit Court judge, who will later rule on motions to dismiss filed by the NCAA and U of L. Judge Mitch Perry will decide whether to dismiss U of L from the case and proceed against the NCAA or whether to drop the lawsuit altogether. The judge did not offer a time frame for issuing his decision, which he said will hinge on the "sweet spot" of the case, whether or not Florio needs to use the university as a legal device to sue the NCAA. The group of fans, known as University of Louisville Protection and Advocacy Coalition, are seeking the reinstatement of 123 Louisville men's basketball wins, including the 2013 title. The case could set precedent for fans to use local public institutions to sue the NCAA over penalties or other disciplinary decisions. Close Hancock is one of several players who is suing the NCAA and is tired of answering the question about prostitutes nearly every day. Louisville Courier-Journal. Florio told the Courier-Journal that the vacation of wins and the NCAA's insistence that the games no longer exist is what specifically gives fans legal recourse. "I think that's the real heart of this issue, is the NCAA just can't go back on its own dicta and change history because of some arbitrary rule it wishes to enforce," Florio said. The NCAA argued Wednesday that revoking the 2013 title does not constitute a breach of contract with the fans, while U of L again asked to be removed as a party in the lawsuit. Florio said the fans are not seeking remedy from U of L and argued that including U of L as a party was necessary as a conduit to sue the NCAA. "If the NCAA will stand up and say they are properly served in this court, U of L can leave," Florio said, but NCAA attorney Charles Stauffer and U of L attorney Craig Dilger said the university must be designated as either a defendant or plaintiff to be included in the pleadings, and the fans have no right to file on behalf of U of L as a plaintiff. Addressing the breach of contract claim, Stauffer said fans who bought tickets to the 2013 game between Louisville and Michigan had purchased the right to spectate and that U of L and the NCAA had delivered that experience. Stauffer said Florio had incorrectly characterized the NCAA's ruling as the equivalent of turning back time and barring fans' entry to the game. Related, NCAA gets extension to respond to ex-Louisville basketball players. "They got exactly what their contracted right was, that they attended the games," Stauffer said. Florio disagreed. "The fact that I saw a basketball game is not what I bargained for. What I bargained for is to see a national championship," he said. If the NCAA would have put as a caveat, "This will determine the 2013 national championship, unless we change our minds," then I don't think I have a case. But that wouldn't get a lot of people to go to that game, would they? U of L PAC leader Anthony Cotton, the plaintiff in the lawsuit, told the Courier-Journal that the fans are not arguing that U of L should have escaped a penalty. He said the group feels U of L's self-imposed sanctions were enough and that the NCAA's subsequent vacation of the title and wins was overkill. "We felt there were two penalties," Cotton said. "We took the death penalty and then the NCAA came back with more." In addition, Florio said, the activities U of L was accused of arranging for recruits to have sex with women, whether paid for or not, are not outlawed in the NCAA handbook. While the NCAA's online manual does not specifically mention sex or prostitution, the organization in its original ruling against U of L characterized those actions as providing impermissible benefits. "When someone has to obey rules, they have to be on notice of those rules," Florio said. "It's sleazy, and paid for sex is sleazy, but college students have sex all the time. And according to the women, the escorts, they said, we were never paid a dime. Just wanted to have sex with cute boys." See also, ULAA. text messages document Pitino's recruitment of Brian Bowens before said he was not authorized to comment publicly about the case and referred questions from the Courier-Journal to the NCAA Communications Office. The U of L PAC lawsuit runs parallels to a case in which a group of former Louisville basketball players, members of the 2013 team, are suing the NCAA for the restoration of the title, accolades and wins in addition to monetary damages. Florio said the two cases are unlikely to be consolidated because the classes of plaintiff are different. He said the former players have a more solid standing in their complaint because they were more directly induced by the NCAA. The former players' case may also end up in federal court if the amount of financial damages they seek exceeds the maximum for state court. Florio and Cotton have asked for up to the maximum of $74,999. "We're all trying to get to the same place, and that's to get the championship restored and the Final Four restored," Florio said. Danielle Lerner, 502-582-4042, The Lerner at courierjournal.com, Twitter, @Danielle Lerner. Support strong local journalism by subscribing today. www.courier-journal.com/Danielle